Mr. Alexander.
The next topic is what I shall neutrally describe as the second and third questions. And the reason I describe them neutrally is because in this case, until December last year, it was common ground between the parties that the right questions to ask in this case were the improver questions. The entire case was developed on that basis, and so among the many jurists who have approved, or at least not disapproved, the improver questions and the approach to dealing with a case of this kind was, of course, all of the jurists on the other side of this court until relatively recently. Now, they seek to replace the questions that your lordships ought to ask with their protocol EPC 2000 questions, and I'll come on to those in due course, because we say even if you do replace them with those questions, we succeed under those questions. But your lordships do have to have in mind that we are dealing with a situation of a case which has actually significantly changed in that respect. Can I then show your lordships why we submit that the courts below were correct in their approach to the questions that do fall to be asked in determining the issue of scope of claim, the second and third questions, and start by drawing your lordship's attention to the second question as decided by the judge and upheld by the court. And for that, you will need core volume 2, tab 13F.
Yes.
And the first point that you need to bear in mind, and in a sense it is a response to one of my Lord Sumption's points, relates to what the invention is or who the skilled addressees are to whom the invention is addressed. And the judge dealt with that in our respectful submission entirely reasonably by concluding, in a decision that is not actually challenged, that the addressee of this invention included both the oncologist and the chemist, and that's why the common general knowledge perspective for assessing the nature of and what was important about the invention was to be assessed both by reference to the perspective of the oncologist and the chemist. And your lordship sees that on bundle page MS 476, paragraph starting 68, where the judge assesses the perspective of the common general knowledge of the oncologist, down to 73, down to 74, and then assesses the common general knowledge of the chemist in the passage from 75 to essentially 86. Now, some of this material will, of course, be familiar to my lords, because the Court of Appeal endorsed that approach and the judge's findings, which were essentially findings of fact as to the right approach to take and who the skilled addressee was, and the knowledge to be attributed to the skilled addressee, in the passages on the science that I invited your lordships to read yesterday evening. And you see the passages from the Court of Appeal's decision reflected in the decision of the judge, going on at paragraphs 80 to 86, concerning the impact of the salt form on the drug and the difficulties in making salts. And I would invite my lord just to mark those, and in particular to mark paragraph 82, which was picked up as well by the Court of Appeal and agreed with, and the subsequent paragraphs on the specific salts and the free acid in paragraphs 83 to 86. So then the judge, having formed that view, which is not really even susceptible to challenge, let alone erroneous in principle, went on to consider the improver questions from the perspective of that team, that addressee, set of addressees, in his evaluation on paragraphs 120 onwards. And if I might just invite my lords to read, perhaps reread, because you will have done so already, paragraphs 120 to 128, that is MS 493 to MS 495. And some of it obviously can be skipped, but it is the core reasoning that underlay the second improver question. And as your lordships see, I apologise, some may not have finished. As your lordships see from paragraph 128, the judge took account of the argument that is raised by Lilly, that there was undue focus on the specific form of the claims as Swiss form claims, and he didn't, actually. He said, well, that's a factor, but he said that if the proposed source of pemetrexid anions is not sufficiently soluble or is not pharmaceutically acceptable, some other reason, then as a practical matter, the skilled team cannot make the medicament or product, and therefore cannot obtain the benefit of the patented invention. And so what one might say is that when one is analysing the question of what the invention is, one needs to be comprehensive in considering it from the perspective of the right skilled addressee, having regard to what the purpose of the invention is. And if you put your eye over one part of what is important, namely that a particular pharmaceutical that can actually be made, delivered, is itself safe, because in relation to some of the salts, obviously there are safety issues and can be manufactured. Put your eye over one part, you can say, well, the invention is about this, but without actually recognizing that the invention is delivering a benefit as a whole. If one thinks about, for example, potassium, one might say, well, that is actually a set of counterions which have their own side effects. We know that from the technical evidence. In that case, potentially cardiac side effects. And so even from the perspective of an oncologist, leave aside the chemist, one might say, well, actually, if the invention is a better or good form of delivering pemetrexid in a way that doesn't produce unreasonable side effects, taking into account the salt form and the specific salt form claimed is a reasonable thing to do. And your lordship sees that from the evidence that I drew your lordship's attention to yesterday. So then if one looks at the matter in the Court of Appeal, turning back to tab C in that bundle.
I find all this reasoning quite sophisticated and difficult. I mean, why does it matter at all if what you can? Why is the skilled expert why is his view relevant as to whether this alternative will succeed?
That's an easy question.
Thank you.
Because for all patent matters, everything must be looked at through the eyes of the person skilled in the art. Construction, infringement, validity, whether something would be obvious or not. And the person bringing his or her eyes to bear on the document in question is assumed to be equipped with the common general knowledge of a relevant person. And so one is not looking at a patent through the eyes of a lawyer, as it were, or not exclusively through the eyes of a lawyer.
No, but I mean, why can't the skilled person say, if this works, it's equivalent. If it doesn't work, I'm not in the slightest interested in it. And,
right,
and nobody is. And nobody is.
Well, your lordship could do that, but I think it's fair to say that every one of the major patent jurisdictions has an aspect of determining equivalence, which involves determining whether or not it would have been obvious that the alleged infringement worked in the same way.
Because otherwise you are patenting something that doesn't work. And,
there are a number of reasons for that. One is this.
Effectively protecting something.
It would be added matter, wouldn't
it? There's a possibility of protecting added matter, but there's in fact an even more fundamental reason, which is this. If one's thinking about scope of protection, again to use a neutral term, you might say, well, what you don't want to do is sort of load the scales entirely in favour of the patentee by simply saying this. If it turns out many years later,
yes,
as a result of work done by other people, that X works in the same way as that which you have claimed, then it would actually be unfair for you to have a claim to that, because you're then effectively claiming the work of someone else on the mere basis that it works in the same way and in a way that does not owe anything to your disclosure. And that is why, when one's thinking about equivalence across the whole of Europe, everyone thinks about a question, let's say a second question, in a common way or similar way to that of the second.
Even though there's no inventiveness in getting this alternative to work.
It may not require inventiveness as such, but it may require predictability. And I'll show my lord a little bit of what Mr. Justice Laddie said in relation to that in the Merck and Generics case, because in our submission he summarised the position correctly.
There's no force in the argument that it's sufficient that the skilled expert would know that there was likely to be an alternative unless he can put his finger on what it is.
Perhaps that's not quite the precise formulation. Once his finger has been put on what it is, so to notionally put on what it is at the relevant date, the question has to be whether, with his common general knowledge, it would be obvious that the invention or the notional variant would work in the same way. And as you have seen from the other jurisdictions, all of them have that kind of test. And there is a live dispute, as it were, as to whether it should be done at the date of priority, publication, date of the alleged infringement. But each of them have that test. And the reason for having a test of that kind and making it a notional test is this, and it actually highlights a difficulty with one of Lilly's proposals for an EPC 2000 test. If you say, in relation to something that, where the question may be, can something be made at all, you assume that the skilled person has the product already in their hand. That contains a concealed piece of information, namely that it can be made. And if one thinks about the improver case, one can think about it in that way as well. And so you've effectively put your finger on the scales in relation to that test if you do it in that way. In any event, coming back to the have I answered at least
I think so, yes.
my Lord Mance's question enough for the present? So if we then come back to the way the Court of Appeal addressed this issue, again they addressed it in a similar way to that of the judge, and you find that at tab 13C, MS 424 to 425.
Thank you.
And again, I would perhaps invite your lordships, you can probably...
We did look at this
rather more
before.
briefly. You've looked at this before. It's paragraph 62, actually over
Yes.
to 71.
Yeah, we did look at this.
And I think you have looked at it before. And in our respectful submission, it is a correct and proper reflection of the, not only what the law is, but also what, in our submission, the law should be.
We looked at some of these, 424. We looked at some of these paragraphs, it's fair to say.
Yes.
We didn't.
It may be useful, just so that your lordship has the composite,
Yeah.
actually just to read 62 to 74 as a whole, and then I'll make some brief submissions on that.
So 67 and 68 really are the finger on the balance point.
Yes. And
Sorry, I just need to interrupt.
yes,
you.
I'll allow my lord to finish reading, and then I'll make just a few brief submissions.
Yeah, so we finished with 73 at the end of that part of the job.
Exactly.
Yep, thank you.
And if you finished at 73, you've also read the point on the third protocol questions,
Yeah.
I'll just develop that as a separate point in a few moments. The first point on the finger on the scales is in paragraph 67, and if I might just invite my lord's attention to the way in which this was dealt with in Merck and Generics by Mr. Justice Laddie, you will find that at Authorities Volume 3.2, at tab 24, MS 3465.
Yeah. 3465.
Indeed.
Thank you.
And incidentally, this is a good case illustrating the proposition that Mr. Justice Laddie, notwithstanding his criticisms of Amgen, had in practice an approach that was absolutely consonant with that and would give effect,
Well, that's his job.
as a matter of principle,
That was his
to
job.
limitations.
That was his job then.
My lord, yes, you might say, well, it's before Amgen, but no one suggests that he was straining at the bit. And if your lordships read this case, you'll see that there was good reasons for limitation. So there are just two passages I'd invite my lord's attention to. One is paragraph 40. MS 3480.
Yeah.
And paragraph 41 to 42. And I just invite my lord to read those, because at 43, he concludes that in his judgment, the same principles underpin the protocol.
Paragraph 40 and paragraphs.
Paragraph 40 is at one point on fairness to the public, and then in 41 and 42,
Right.
he gets to the nub of the issue of the importance of giving effect to appropriately precise scientific language in appropriate cases.
Yeah.
And then in paragraph 43 to 45, he says, first of all, the same principles underpin the protocol, and then first sentence, protocol is directed to prohibiting acontextual construction, paragraph 44, and then the second sentence emphasizes the primacy of the claim. Notional addressee is not expected to find the patent's presumed intention from the specification. Particularly, as noted earlier, this sentence makes clear that just because a reading of the specification suggests that the patentee contemplated a wider protection than set out in the claims does not mean that he obtains a wider protection. The patentee is taken to know the rules. If he wants a monopoly which covers all embodiments, which he contemplates may make use of his technical contribution, he should use language conveys that intention to the notional reader, and that language should primarily be found in the claims. He says it conveys the same message as the protocol.
Just going back to paragraph 42, the second sentence, he may not be able to foresee future developments which will be usable with his invention, but which make no material difference to the way it works. How is that consistent with your submission that the skill...
It's entirely consistent. Indeed, as Lord Hoffman explained in Amgen, the approach that one takes to dealing with non-contemplated equivalence involves saying notionally the skilled person is presented with the, let's call it the radically new alleged variant at the, in this case, a publication date, and is asked, does it work in the same way? And would it have been obvious to the skilled person that it worked in the same way? And then, of course, the third question in relation to that.
If the answer is, I don't know if it works, but it's something absolutely blindingly obvious to try and see, and it may well work, what then?
Well, there might be cases where, I mean, working and seeing and experimentation are all, in a sense, terms of degree. On one view, you decide whether or not there is a jug of water on your lordship's desk by performing an experiment consisting of visual examination of the desk. So one can't be,
well, yes, but I mean,
can't be too prescriptive.
Well, yes, I mean, it's clear that potassium, very similar to sodium, same group, and clearly well known as a cation in this sort of area. It's pretty obvious that, particularly if you want to get around the patent, pretty obvious thing to try.
Well,
and pretty good hope of prospects of success, particularly if you look at the risk to reward basis. Very easy to try, very obvious to try, very real prospect of success. Now, if we're into degrees, how do we bear that in mind?
Well, Ms. Josseladi actually dealt with this issue as well, and in a passage that I would commend to you,
right,
at paragraph 78.
Thank you. Yes.
Which I would invite your lordships to read.
Little or no doubt that the variant will work.
My lord, yes, and there is
why such a high test? If it's easy, if it's obvious to think of it, and pretty easy to do, why does the mere fact that it only may work knock it out?
Well, what we would submit is that if you believe, and this is a matter that I've addressed your lordships on separately, that a person ought to be able to predict from the specification of the patent and the claims what is within it and without it, effectively, albeit notionally with after-acquired, in the case of after-discovered inventions, notionally with it before you, then there ought to be a high standard of predictability with respect to that notional thing. One ought not to have to undertake an experimental program in order to determine whether or not it would have been obvious. And what Mr. Justice Laddie does is there, and we respectfully say rightly, is that one should not turn the second question in improver into a full-blown examination of obvious to try with reasonable prospects of success and so forth, thereby rendering effectively a question of scope of claim into a question of whether or not a particular variant would have been obvious pursuant to quite different tests for different purposes. And in our respectful submission, that is a sensible and principled approach.
Well, why is it, I mean, he doesn't actually have to foresee the variant, but he does have to foresee that if the variant is presented to him or her, it works to a high degree of confidence. I mean, why is it relevant to look at the date of the patent's validity, or whatever it's called, priority date for this purpose? It seems to me that would be relevant if one was dealing with a pure question of construction, but certainly this question is not a constructional question. This purports to be something else.
You're right that it does purport to be something else, but if one is interested in determining the question of whether a given alleged thing falls within or without the patent, there is, we would submit, a powerful case for saying that ought to be establishable on a fixed date and ought not to change during the life of the patent. It ought to be evaluated by reference to the common general knowledge
but it is
at the outset.
By definition, it isn't it? Because you're introducing a variant, as you said earlier, a given variant which may not have been foreseen at that date at all. So you transport that back to the priority date, but somehow you then cease to transport anything else back. You require it immediately to be obvious that this is the eureka solution.
Well, the question is not one of transporting everything else back, because the material that a skilled person has to work with, as it were, to undertake the exercise, in at least for the purposes of the second test, is not only the patent specification and obviously the claim, but also the common general knowledge of the skilled addressee at the priority date or the date of publication of the patent. And so the idea is that one doesn't, in asking this question, take what may have become common general knowledge at a later stage and may have become common general knowledge as a result of nothing that owes anything to the work of the patentee, to then say, oh, well, because we now know and because you have discovered that a particular device or compound works in the same way, we are now going to attribute that knowledge effectively to the notional skilled person at the priority date for evaluating the question of whether it would have been obvious at that date. And again, we say that would not be presenting a balanced approach in trying to determine whether or not an equivalent was an obvious variant in a way that provides stability over the life of the patent. In any event,
it seems a remarkable reward for doing a few simple tests that you can evade the original patent by showing that your further non-inventive thought is one which required a few simple tests to elucidate the effectiveness of. anyway, that
Well,
is.
again, there may be questions of degree here as to
Yes, you accept.
the simplicity of the test.
No, you accepted that.
Because, and for the purposes of your lordships, if I may say so, it may be that one doesn't need to harmonise any more than is already harmonised, because the reference to obviousness does encompass a range of ways of doing things that may be appropriate for different fields of technology. So in our respectful submission, this aspect of the test is perfectly adequate as it is.
Well, the only thing is that you say it's a question of degree, but would it be right to say that Mr. Justice Arnold didn't approach it like that? He said it wasn't clear whether it would work, end of point.
Yes.
No question of degree there.
That's perhaps a slightly different point. He said there was no question of degree there.
He didn't say that.
He didn't. Not in terms, but the concept was that it was not a question of degree. My point as to what was a question of degree is what kind of activity one would need in order to establish the obviousness or non-obviousness of the equivalence. And
I mean, they are all well known, as he said. These different potential cations are all well known.
Well, actually, no. Trimethamine, not well known, not much used, and the important aspect about that is that it's not just a question of what was known. The question is what was known about relevant characteristics of the salts, because in the passage that
paragraphs 83 to 86.
Exactly, and it's no good with respect saying, oh well, all of these were known. That's true. And indeed, with arguments in relation to obviousness, sometimes the arguments are, well, all of this was known. So it must have been obvious to undertake, it must have been obvious to individuate any one of them. Sometimes those arguments succeed, sometimes those arguments don't, and they're dependent on the predictability, the nature of the field, and so forth. But for present purposes, all I would submit is that the analysis undertaken by Mr. Justice Arnold and by the Court of Appeal of that aspect was not an incorrect analysis for the purposes of Improver Question 2. Can I then turn to Improver Question 3? There's one other point just before I leave Improver 2. On paragraph 50 of Mr. Justice Floyd's judgment, there was a suggestion that this was not right. In some sense, we don't disagree that undertaking salt screening as such is routine. It's actually not. It doesn't follow from that because of that work is so easy, one should deem the skilled addressee to know its outcome, and thereby effectively treat it as though it was part of the common general knowledge with respect to which the skilled addressee was evaluating the patent. The whole point is that this was unpredictable, and I've given my lord the references in relation to the unpredictability of whether given salts would have physical and indeed biological characteristics that would make it an attractive and indeed makeable medicine at all. So that's really all I'd want to say about question 2. On question 3, again, if we might take it from the reasoning of the judge first of all, and then look at the way that the Court of Appeal dealt with it. So if I might invite my lords to go back to Mr. Justice Arnold's judgment, tab F at MS 495.
Right.
And I just invite you to read paras 130
Right.
over to, unfortunately, there's quite a long section.
Yes, it is on the third.
But
149.
It's really 149, unfortunately.
Would you like us to read all that?
If you haven't read it before, as it were, it does repay study now, If you have, then I'll go on rapidly.
Well, we have, but possibly a bit of time ago in terms of familiarity with this case.
I think it does repay study, because there are multiple reasons.
If you'd like to sit down while we do that, you're very welcome. Thank you. Yes.
My lords, then, if your lordships might just, for completeness on this, pick the matter up in the Court of Appeals.
If you just take, just before you do that, if you take paragraph 133 of Mr. Justice Arnold, where he said the skill team would not only notice the difference in language with the other elements, but it also regarded as explicable by reference to the fact that no other form of Pemetrex was known to be efficacious and safe. Well, I thought, isn't that circular? I mean, I thought the whole point of what you were explaining about equivalence was that something could count as an equivalent and satisfy that element of the second, improve a question, because it was not foreseen. And yet here he says, well, because they didn't foresee it, it can't be an improvement. It can't be an equivalent.
My lord, we're dealing with two different issues. This issue under the third improver question is whether the claims should be essentially held to their natural and precise meaning.
You can win on one ground under question 2 and lose on the same ground under question 3.
Well, My Lord, I'm not sure that that would quite follow. The point is not that one would. One might win on one for one reason and lose on the other for a quite different reason. And the different reason might be, or would be in a case of this kind, and was in the case of Ranbaxy as well, and Merck and Generics and other cases, that even though it would have been notionally obvious to the skilled team that there would be a variant that worked in the same way, nonetheless, there may be a good reason to confine the patent to its strict meaning. And one of those reasons, among many, might be that that was the only one that had been proven to work in that way. Because if your Lordship considers the specification here, there was only one that had been proven to work, and your Lordship knows that there is a law relating to insufficiency if you claim things we haven't actually adequately disclosed them. And there are difficulties about predictability, your patent may then be invalid for insufficiency. So that there are good, what might be called technico-legal reasons for saying I confine myself to that which I have specifically disclosed, identified as the only embodiment in the specification, even though it may be that one might be able to predict that others might work, but we haven't done the work to establish that.
The trouble with that is that equivalents will never be known, will they? I mean, otherwise you would specify them.
No, there would be, well, that point cuts two ways, because if that's right, then what, and indeed as I said, there are shades of that in American jurisprudence, that if, just as in relation to the vitamin B12 point, precisely because there were known analogues of vitamin B12, the patentee wrote them down, claimed them, and justified that claim by reference to technical information relating to them.
So that explains why he didn't do it here.
Correct.
But it doesn't exclude the possibility of equivalence.
Well,
I mean, equivalents are going to be most useful when you haven't, the principle of equivalence is really likely to be useful when you haven't actually foreseen something.
Yes, but you might say, just following my Lord's point, that while it is useful if you haven't actually foreseen it, if it was in fact foreseeable and you haven't claimed it, that cuts against you rather than in your favour, because it might be said, well, if that's the case, you're particularly likely to have had a deliberate reason for excluding it. And this case might be said to be a sort of hybrid of that, where there are good technical reasons for supposing that a skilled person would have wanted to limit themselves in this way, precisely because other salts had different characteristics.
Well, the danger the other way is once you start claiming a few, you then much more powerful, you said you've shut out the rest. If in this case they claimed 4, then there'd be an even stronger inference, or a less weak inference, depending on your view, that they weren't intending to claim any others.
Well, that may well be the case, but one might say that so be it, and that gives effect to fair protection both for the patentee and to third parties, in that the patentee has then disclosed and claimed those, the set for which it was confident, leaving potentially a wider set to be claimed or pursued in a divisional if it wanted to, and said, for this patent relates specifically to this. And in our respectful submission, all of those reasons are sound reasons for limiting it. So Lilly's answer is, well, the judge and the Court of Appeal had lost sight of what was important about the invention. Our respectful submission is absolutely not. What they were doing was looking at the invention from the perspective of the team that was actually interested in the invention, including the oncologist. Your lordships will have in mind that one of the reasons for Mr. Justice Arnold's conclusion in relation to the facts here and the perspective of the skilled team was that Lilly's oncologist, not chemist, was asked whether he agreed that it would be the presumption of oncologists that the chemists involved had specifically chosen the disodium salt for a reason. And his response was, I absolutely agree with that. And that is why Mr. Justice Arnold concluded, as he did, in his fourth reason. And so all of these provide very good reasons why a skilled team should say this is a term that naturally is a term of precision to begin with, and there are good reasons why it should be held to be a term of precision, and that in this case precludes equivalence. And one has to be a little bit careful about Lilly's case, because they say, well, one ought to have a rule that says equivalents are allowable regardless of what the claim says, or equivalence to any integer, regardless of what the claim says, in every case. And our submission is more modest. Of course, equivalence must be taken into account in every case. But there are some cases, of which this is one, and there are many others in the law reports, where precision is provided for, precision is claimed, and precision is there for a reason to which effect should be given. And so when the Court of Appeal upheld Mr. Justice Arnold in paragraph 72 of tab C, MS 426, he was right.
Yeah.
And none of those points fail to give fair protection to the patentee, nor reasonable certainty to third parties. They strike the right balance under the existing improver questions. And if you take up the proposed protocol EPC 2000 questions, at least the third question we would submit falls to be answered in exactly the same way as it would be under the third improver question, because the question then would be, based on the description, drawing, and the claims, would the skilled person nevertheless understand the variant to be excluded from the scope of protection? And all of the points that were made by Mr. Justice Arnold, and all of the points upheld by the Court of Appeal, would apply with equal force were that to be the reformulation of the improver question for exactly the same reasons. And one sees that in a sense, both in the decision of the Oberlandesgericht and in the decision of the Swiss court in relation to this case, and one sees that in numerous other cases where people have been held to the precise wording of their claims for good technical and legal reasons. So in our respectful submission, the courts below were right, and the very fact that they were right suggests that there isn't really any need to make this change to the questions that are proposed. No one has proposed questions in this form in any other jurisdiction. No one has suggested that this is what is needed. And in our respectful submission, the improver questions adequately do the job, at least for the time being. So may I turn to two very brief points in relation to scope of claims, regulatory matters and Swiss claims. Regulatory matters I'll just deal with very briefly. The test is quite different. Your lordships have the material. On Swiss claims, the only thing that I would invite your lordship's attention to is Ranbaxy, which, and you don't need to read it now, because I can just make some rather crisp points on it.
Just tell us where it is.
It's in Authorities Volume 3.3, tab 30, and it's a decision of Mr. Justice Kitchens, which surveys the law on Swiss claims.
Oh, yeah.
We respectfully agree with Lilly that the Swiss claim point isn't determinative in this case, and neither judge nor Court of Appeal held that it was in any relevant respect. But we would respectfully suggest that Mr. Justice Kitchen's observation that you actually had to give effect to the actual claim wording, which is what he says in paragraph 36 to 41, and
yes.
People would be understood to understand the relevant drafting conventions, is law that should commend itself to you, and that one can't simply say that because the law has now changed to, in a sense, liberalize the way in which these second medical use, these medical uses may be claimed, one should therefore ignore the way in which they used to be in the past. The second point, though, of more pertinence to the direct infringement appeal is that none of the fact that the claims are in Swiss form does not mean that one therefore gives them a broad or narrow construction with respect to an individual integer that is essential to go into the medicament.
But it could be said that what, I read it very quickly, but what Justice Kitchen says in paragraph 55 could be said to provide some support, could it not, from Mr. Mitchison's point? He's really saying that although these are drafted as manufacture, they'd be understood as meaning treatment, as it were, or use.
Yes.
Is that a fair reading?
To that extent, that is a fair point. Although we would say it doesn't really matter for these purposes, because no one has been looking at this as a manufacturing issue.
I see.
The point is, it is a product in this sense. Mr. Mitchison is right. What is disclosed is a pharmaceutical, but there are different characteristics of a pharmaceutical. One of which is efficacy. Another one of which is deliverability to the patient, non-toxicity to the patient, non-excess solubility, pharmaceutical acceptability, and so forth. And one can't just, as I said, put one's eye over one of the aspects of the invention. So we would respectfully submit that that is the summary in Swiss claims. In our case, we've also referred to a number of the Board of Appeal authorities relating to Swiss claims, and you were taken to some of them already. There's no difference in result that there would be with a EBC 2000 claim. So may I then turn to the final topic before I hand over to Mr. Raphael, which is to make a start on the foreign law aspects.
Sure.
And in view of the relatively brief way in which it was dealt with, I think I can be relatively brief as well. I'll deal with general points and then France and then hand over.
Okay.
General points on foreign law. First of all, for each of the countries that were in issue, so France, Spain, and Italy, the judge had the benefit of 4 expert reports, which, as he said, were clear and well-reasoned from among the most eminent practitioners and academics in the field. They produced considerable agreement, which your lordships have seen in the joint memoranda of the experts who met before the trial. And the judge read the underlying foreign law materials as he recorded in his judgment. There was quite a lot of case law. We haven't troubled your lordship with all of the case law for the purposes of these bundles. Secondly, as you will know, in several countries in Europe, the doctrine of precedent is not quite the same as it is in this country. And one has to look to sources, sometimes academic sources, sometimes a set of jurisprudence constante. I shouldn't try French anymore.
Wasn't directed at you, Mr. Alexander.
And so forth, in order to get a sense. And in that context, it is right, particularly in a field of this kind, for a trial judge, not only to get a sense of the general principles of law that are applied, but also how they are in fact applied in practice. Because as you will have appreciated, some of the propositions in this area of law are stated at quite a high level of abstraction, and they don't really come to life unless you see how it's actually done. And the judge had the benefit of a series of cases to which he referred in his judgment with illustrative examples of how the relevant aspects of the doctrine were applied. He did what the English cases said he should do when foreign law is an issue, namely using his own intelligence, to use the words of Lord Justice Scott in Talina. He evaluated what the experts had said, in some respects preferring one, in some respects preferring the other. Third, he was applying law which in a sense has common origin, and namely the EPC. And he was, in a sense, particularly well equipped as an evaluator of both foreign law and its application of it, as someone who not only has experience of doing that under a jurisdiction, but also has knowledge of the differences that there are between the foreign laws. He did not take as it is suggested in Lilly's case, a kind of English approach to say, well, because this is what we do in England, the result and system has to be the same under other foreign laws. He adopted a rather nuanced approach, and one might say as good an approach as one sees in the jurisprudence of the foreign countries themselves, in terms of clarity and focus in all of the foreign laws. And his conclusions were therefore really barely challenged. One thing you will have noticed, and Mr. Raphael may develop it in greater length, is that there were some differences in the approaches in foreign law, and he took those fully into account. So can I turn very briefly to France and invite your attention to the appendix part 3, and just answer my points put against us. Yeah. It's useful just to see how Mr. Justice Arnold dealt with France and to have that out as well. It's Core Volume 2, tab F, at paragraph 159 onwards.
Right.
And again, I don't invite your lordships to read that now, because all of this is unchallenged.
And we were taken to much of it.
You were taken to much of it, but the only thing I would invite you to do is to note that what Mr. Justice Arnold took was almost verbatim from the agreed report of the two experts. This is not him going out of line. To the contrary, this was absolutely in line with the experts. And if your lordships look at the material from France, you may think that this is a jurisdiction which, perhaps unlike some of the other common law jurisdictions, is not easy to interpret by looking at particular cases without the assistance of experts, partly because of the approach that they take to precedent being set by courts and so forth. And so he had active assistance from the experts.
Right.
And in paragraph 160, just to make good a point I was developing earlier, he not only looked at, in detail, at the question of the distinction between moyens particuliers and moyens généraux, he looked at specific examples of the application of these doctrines, both on one side and on the other side, in the cases before him, some of which are in the bundles. And the key cases were Institut Pasteur and Mundipharma and B2M and ANCOM. And in relation to the second aspect of the case, prosecution history, the relevance of prosecution history, he looked specifically at how this doctrine had applied in Hewlett-Packard. And so when he came to his conclusions and assessment in 163 to 165, he had equipped himself really as fully, and if your lordships actually read the French law judgments, you might say even more fully in some respects than some of the French law judgments themselves, with the full theory and application of the law in question. And he came to a conclusion there that applying the French law, the equivalents or alleged equivalents were not within the scope of the claims for two reasons. First, because there was a moyen particulier that was involved here, and if your lordships look, and I don't want to take up time by inviting you to look at it in detail, but if you look at the Mundipharma case, which concerned a substitution of a particular alleged equivalent in the context of a pharmaceutical slow-release device, you can see that the approach that he took to moyen particulier was not just in accordance with the doctrine, it was in accordance with how the doctrine was actually applied in the cases before him. The function was not novel. Function there with the efficacy was inhibiting tumor growth. In relation to this case, function of the pemetrexid disodium was not novel. Function, which was a known function, was efficacy in inhibiting tumor growth, and that was known at the date of the patent. There's a close analogy there. And secondly, that the prosecution history, which he analyzed the law, showed that the claims were limited in that way. There was, of course, in France no suggestion of any doctrine that one could only take account of prosecution history with respect to certain objections from the examiner. There was a global approach. Any limitations to the specification would be taken into account, and the French lawyers were ad idem that the prosecution history was of importance in determining scope of protection in the context of French law. So even if he had been wrong in relation to the first point, his second point would have been entirely unimpeachable. But he wasn't wrong.
What was the second point?
The prosecution history.
Yes.
Prosecution history point.
Yeah.
But he wasn't wrong. He had the assistance of two experts, who neither of whom referred to the material that was said to be determinative in either of their experts' reports, neither of whom suggested that there was this, it was suggested by Lilly, that there was the approach that they say was the approach. The new textbook extract was in effect significant precisely because it was authored by them and neither of them had referred to it and was simply put into the bundles at trial, was if anything a point against them, because it might be said, well, if this was so important, why on earth wasn't it mentioned by the experts in their reports? And in fact appears on its face prima facie inconsistent with the application of the law, both in the Institut Pasteur and the Mundi Pharma cases. There was no further report served by Lilly saying, here's a further point in relation to this, which obviously they could have done. And before the Court of Appeal, although I wasn't there, the propositions that that it contained were said to seem extraordinarily broad by Lord Justice Kitchin. And we don't know whether that will be regarded as compliant with Article 69, what the source is, whether it's actually from a case, whether it's from another article, that the footnotes are not provided, and so forth. So in our respectful submission, that simply doesn't help, nor does the case in question, because it doesn't undermine the DL and Helga case, doesn't undermine the fact that when you're considering the question of whether there's infringement by equivalence of one of the means of the combination, you consider the function of that particular integer. So in our respect, and nor did either of the experts cite that or suggest that was for this point, or suggest that that was a point of any significance in this context. Although, again, in a sense, significantly against Lilly, they referred to DL and Helg for a different point. So in all respectful submission, there is nothing wrong with the judge's determination under French law. And under ordinary principles of review of judges' decisions, to suggest that this court is in a better position to make the findings relevant to French law than the judge was, we respectfully submit is an ambitious one. And so on that note, perhaps I could hand over to Mr. Raphael to explain why the position is no different in Italy and Spain.
Thank you. Yes, of course.
Sorry.
My Lords, Lilly accepts the judge's findings of Italian law and now seeks to run arguments of application only. Sorry, I should say I'm dealing with Italy first. It says it runs applications of application only. If we could turn to the judgment briefly, which you'll find in Core 2.
Yes. Starts at MS 503, doesn't it?
Yes, indeed. It's paragraph 173, which is MS 50.
Yep.
We should probably start.
The
relevant passage is at 173 MS
Thank you.
506, because it should be borne in mind that Actavis pragmatically just took its stance on conscious limitation. It didn't need to engage with earlier bits of equivalence because conscious limitation was sufficient for it. And the law on conscious limitation is set out in paragraph 173. You see he records Professor Fransosi's opinion that if it is evident that there's been a conscious limitation to the claim, then the doctrine of equivalence is excluded. And he goes on to give the example of EG and AstraZeneca, where the court held that EG's product did not infringe a claim requiring a minimum of 99.8% in antimeric excess of esomeprazole, because this was a clear limitation in the claim. The point I take out of that, my lords, is very simple. This is an objective doctrine of claim construction, and so the judge has found. If there's any argument against that point, there were some suggestions that were not developed in Mr. Mitchell's submissions. You'll see that in that paragraph, accordingly, I accept Professor Franzosi's opinion on this point. He is accepting Professor Franzosi's opinion, and Professor Franzosi's opinion was exactly that this was an objective doctrine of claim construction. We set out the reference in our case at paragraph 215. Indeed, the point was never disputed by Mr. Mitchell's expert, Professor Gilmetti.
So really the guts of the judge's decision is in 178 and 179, isn't it?
Well, that's the application, yes. Then the law on prosecution history is set out in paragraph 175.
Yes.
And the conclusion is very shortly, in an appropriate case, the prosecution history can be relied upon as an aid to construction of the claims, particularly where it's clear that the applicant has intentionally limited the scope of his claims during the course of prosecution. I just stress here, it would be entirely alien to an Italian lawyer to run the sort of argument that's been floated in questions by the court, that you can ignore the file because you feed equivalence into the file. That's not how they think at all. Instead, they read the file sensibly, commonsensically, and then if there's a limitation in it, it excludes equivalence. That is their law, and so the judge has found. Nor then, in terms of application, he moves on at 178, and he gives the two reasons given by Actavis. Firstly, that the patent clearly demonstrated a conscious intention of the patentee to limit the claims, and secondly, if there's any doubt about that, it was amply confirmed by the prosecution history. Just one footnote on that, the evidence of Professor Franzosi that was accepted, also the cases, all show that where there is prosecution history, the Italian courts use it together with conscious limitation. Prosecution history is decisive evidence in an appropriate case of the objective conscious limitation. And then he goes on 179 and accepts both points. Lords, that is applying his findings of law in a direct and natural way. Lilly has to succeed on both to win, yes, but it really has identified no reason whatsoever to interfere with either. One thing you've heard from Mr. Mitchell is an attempt to cross-apply his arguments under English law to Italian law, but that can't work. There was no suggestion by any of the experts that anything like what's been put forward to this court under English law was Italian law. So, secondly, Lilly appears to advance arguments of application of Italian law to the facts, but it's very difficult to see how that could be a proper appeal to this court. And it would appear actually to include within it a pregnant submission that the judge misdirected himself as to the law, but that is a challenge to his findings. Well, then just turning briefly...
Is that right? Is that everything he concludes by way of application to the facts is also factual, is it?
Well, there are two aspects to that. If your lordships were to take an entirely different reading of the patent as a matter of fact and what it conveyed in terms of the scope of protection, that is the point that could be cross-applied. But to the extent that your lordships differed, if you did differ, with the Court of Appeal on matters that included aspects of law, that is not cross-applicable. Well, turning then to conscious limitation, I will, if I may, give some brief context to the judge's findings. And one example of that is the case of E.G. and AstraZeneca, which you will find in Appendix 3, Italy, tab 57. And this is a case which is of the Specialist IP Division of the Court of Turin. It is strikingly similar. Appendix 3, tab 57.
Italy.
Tab 30, tab 57.
That's right.
Sorry, I have it. Thank you.
There it is. And the relevant passage, which I'll ask you to turn to, if I may, is at MS 2165.
Thank you.
There's been discussion, and the actual reasoning of the court starts a little bit above halfway up the page at in law. And if I could just ask you to read from there down to on the next page, well, effectively the bottom of the next page, my lords.
At the bottom of page 2166, or?
My lords, I'm obliged, yes.
Thank you. Yes, very well.
So, my lords, that is an approach which contains... I'm sorry, I see I haven't finished. So, my lords, that is a very simple and straightforward approach. It contains no hint of a two-stage approach of the EPC 2000 questions, and our very simple submission to you is it is strikingly similar to the facts of this case. It is strikingly similar to the exactly parallel litigation in Ranbaxy and AstraZeneca, which was decided the same way in the UK as in Italy. And if either the Court of Appeal's findings, Mr. Justice Arnold's findings, or indeed submissions that my learned friend Mr. Alexander put to you as to what this patent is about are accepted, then that approach applies very simply. There has been a conscious limitation of this claim to disodium. And my lord, the only point I'd like to pick up before we move on from that is if we could turn to the judgment of the learned judge in Call Volume 2, MS 471. I'm sorry, the wrong reference there. The judgment of the judge at...
Which paragraph?
Paragraph 45. I had the right reference. MS 471. In the third sentence. Secondly, Lilly has admitted that making the amendments was a deliberate and conscious act on the behalf of Lilly. So we don't need to prove subjectivity. If we do...
Sorry, which paragraph was that?
Paragraph 45 of the judgment, third sentence, my lord.
Well, it's clear from
Could it be otherwise?
Yes, and it's clear from the correspondence with the
Indeed.
Patent Office.
I mean, this sort of simply amounts to saying
They knew what they were doing.
nothing is relevant except the words in which they express
That's
themselves.
the trouble.
Lord, it is the approach given by Italian law.
I know, but, well, fine. We're obviously concerned with Italian law in that appeal, but whether it represents the convention.
Well, indeed. It does go to the proposition that an approach giving serious regard to the claims like Italian law does cannot be said to be out of line. But I take that no further. Lords, then moving on to prosecution history.
The starting position in Italian law is that Article 69 and the protocol are directly applicable.
Lord, they apply Article 69, of course, but they apply it under their own law. Their judges have been engaged for many years in saying what that means as a matter of law. And there's been no suggestion in this case that one could do anything other than apply the substantive patent law of those nations as applied by the courts of those nations. That's been common ground throughout. Well, then moving on to prosecution history, we face the problem here that we don't really know what Mr. Mitchison is going to say, because he didn't open his appeal on prosecution history under the foreign laws, and that was not agreed. Lilly's case also says nothing meaningful on this. Lilly, we may
You mean you were taken by surprise when he got up and said that
Yes.
it was agreed that he could?
It was agreed that
Well,
prosecution...
let's see where we go on that. This is not well, there are no cases here which should be decided on that sort of point. If in due course Mr. Mitchison makes a point that you want to answer, you can answer it. I hope you'll do so shortly, but it's a fair you should do so. And if he feels he has to come back, then we'll wait and see. But I don't want you to be, your clients to be in an unfair position.
Well, I'm obliged. We're guessing, we're taking 2 points. Firstly, that on the facts, the prosecution history is not meaningful. Secondly, that prosecution history should be ignored in adamant cases. This is one of those points where there is a real danger of taking matters out of context and failing to apply Italian law. The essential concept the Italians use, as we shall see, is that a deliberate limitation in fact in prosecution is decisive evidence of the conscious limitation of the claims and precludes equivalence. So the question put by my Lord Hodge as to whether one could read equivalence into the file is, as I said, just not how the Italians contemplate this working. And indeed, that would be inconsistent with the judge's finding at 175. I can only give you a very brief snapshot of the materials on this, but could I take you to one article, which you'll find in tab 72 of the Italian Law Bundle. What this is a case report followed by a case note. And the case note starts at MS 2290. The passage I wish to take you to very briefly is at MS 2292. And there's a heading about particular interpretive hypotheses that are not justified and closely linked to the objective content of the document. And then they quote a recent decision of the Court of Milan. And it's considered relevant to interpretation of the patent, inter alia, the limitation introduced by the patent party for the European examiner as an expression of the clear and undisputed intention of the inventor to argue that, in this perspective, the conduct of the defendant can be construed as a file wrapper estoppel.
Where are we?
I'm sorry, my lords, towards the bottom of the page.
Bottom of page 2290.
92.
Very sorry. Start again. There's a heading towards the bottom of 2292, particular interpretive hypotheses. And then there's in the second last paragraph, it's the Court of Milan. And you see that the limitation introduced by the patent proprietor for the European examiner as an expression of the clear and undisputed intention of the inventor produced the result that in this perspective, the conduct of the defendant can be construed as a file wrapper estoppel, a concept of doctrine and jurisprudence according to which those characteristics intentionally excluded by the applicant in order to distinguish the patent of prior art cannot be considered under the doctrine of equivalence. And then that's the summary of the case. And then you see the article writer's summary. The above-mentioned rulings, full interpretive relevance has been given to the applicant's statements in order to highlight the authentic interpretation of the patent proprietor's intention and also to prevent the applicant from restricting the scope of protection of his invention, to bypass the objections of the European examiner, and then to recover by equivalent its original breadth in the assessment of infringement. And there's some other useful discussion that goes on, but given the time, I won't take you to it. Lords, if and to the extent your lordships have leisure and interest to consider Italian further later, can I refer you to a very interesting decision, which is WLP and High Tech, which is at tab 73 in the Italian bundle, starting at MS 2295, EB 2317, and the key passages that, just for your note, are MS 2302 to MS 2303. And there's an extensive discussion which makes exactly the points that we have seen. Namely, Firstly, you start with the objective reading of the claims, and you see where there's a conscious limitation.
So where are you beginning on 230?
2302, I'm sorry, my lords.
Whereabouts?
The passage that is of most relevance starts at point 7 and goes on to the top of the next page and stops before point 8.
Right.
And if I could make summary submissions on what happens here, you have first an analysis of what the claims mean, but then, if that's not clear enough, you have the effect of prosecution history, and you'll find that in particular, you see the last paragraph on that page. From this perspective, in the case in question, the limitation voluntarily introduced by the holder of the patent or the European examiner must be evaluated as a clear and incontrovertible expression of the will of the inventor himself, and then you see, thus, there is no infringement. So it is a very common sense doctrine, and we say that the Italian court, reading the file here, would reach a very simple conclusion. The patentee voluntarily limited the scope of its claims, and so equivalency is excluded.
If you were asked to settle down and give, in respect of each jurisdiction, a case where equivalence had meant something, could you do that?
Was yes, but what we find is a trend. And the trend that has been going on for the past 20 years is a move towards respect for the claim.
I mean, it might be helpful, it's perhaps a point for your opponent as much as anyone else, but it might be helpful that at some point we had the high watermark of the equivalence cases, since they do appear to exist as a trend, albeit you say a diminishing one.
Well, it may be, you may be aware, I'm a humble commercial lawyer, and this may be a question that Mr.
Well, I've
Alexander
never used the adjective of a
better.
commercial.
Yes.
And then the humble one.
No.
Well, indeed. Well,
First one I've met.
First one, quite. All right, yes, you're a commercial lawyer, so it's not your, well, you're doing extremely well, if I may say so.
You'll find till you get a difficult question.
I mean, I think it would actually help us. I know it's perhaps an unfair question to put to you, but it just help us see, or help me anyway, see how far equivalence has had meaning. It's probably as much a question for your opponent.
It is, but what we do say this is, one looks at things field to field.
Yeah.
The cases where perhaps one has a more flexible approach are mechanical patents. But chemical patents like here, the consistent trend in all the cases you see from all the foreign jurisdictions are to give chemical words meaning, and meaning as limitations. My lords, then that leads into the other point Lilly is running, or may be running, which is the idea that prosecution history can't apply in added matter cases. Lords, we say that's a disguised attack on the judge's findings, attempting to impose a qualification which he does not impose. His finding doesn't have that exclusion. And that is not least because it was not suggested to him that there was such an exclusion, nor was there any evidence to suggest such a restriction, and Lilly's expert never suggested it. And that's significant because Lilly was alive to the point and would have raised it with him. Lords, the conclusion that there is no restriction in added matter cases is also obvious from the principle the Italian courts are applying. They simply ask themselves, has the patentee consciously limited his claims in prosecution? If so, no equivalence in relation to matters he's excluded. And that is focused on the nature of the limitation. It is not something that is capable of being affected by whatever was the particular nature of the objection made by the examiner. Indeed, of course, in this case, they weren't just added matter objections. But to the extent that we need it, my lords, we do have a clear example of the Italian courts applying prosecution history in an added matter context. For your note, that is Artsana and Brown at Appendix 3, tab 52, MS 2120 to 2124, and the key relevant pages are MS 2123 to 2127. Lord, we just also stand back and make this point, and it's a point I think was well ventilated by Mr. Alexander before. You are dealing with the foreign system as a whole. Systems that have broader concepts of equivalence than others, well, for those systems, prosecution history is all the more necessary, and one can't rip bits. Lords, those were my submissions on Italian law. Unless your lordships had any questions, I was going to move on to Spanish law. Lords, this actually may be of, again, some assistance on the primary appeal, the appeal for which Lilly has permission, because contrary to the impression conveyed at points, Spanish law applies questions essentially identical to the improver questions. To the improver questions.
Yes.
Down the line. And the Spanish courts have deliberately followed Katnick and improver. And the reference to that is the Olanzapine case, tab 33, MS 1764, EB 1768, third paragraph. The Spanish courts also give effect to prosecution history through the doctrine of actos proprius, your own acts, and also as interpretive material. The judge made 3 findings. Firstly, applying Spanish question 2, which is the same as improver 2, and the same as improver 2 as classically applied in England. It would not have been obvious to the skilled person at the date of application that Actavis's embodiments would work, and given the findings of fact, it's impossible to see how that can be challenged. Secondly, applying Spanish question 3, which is identical to improver 3, that the skilled pattern would read this patent as confined to disodium. And third, this would be rammed home, if otherwise in doubt, by the prosecution history. And Lilly, again, must overcome all of those conclusions of application to succeed. I'll just question 3 first. We can deal with it, I hope, very briefly. If we turn to the judgment in Core 2, tab 13F, MS 509.
Sorry, page?
MS 509, my lord.
509, sorry. Thank you.
You'll see the relevant test at 1823, and that is that is improver 3. And again, to the extent that Lilly's arguments depend on insertion of its English law EPC 2000 questions into the analysis, they can't cross-apply here. So we are simply left with applying improver 3 to the facts as found by the judge. And for the reasons given by the judge, the Court of Appeal, and Mr. Alexander, we submit there's just no reason to interfere with the judge's findings. Lord, then that moves us on. There's perhaps just one other point to note on Spanish law, which is Spanish law has a rigid element-by-element rule. You can't ignore an element for purposes of interpretation. You see that from the joint memorandum, which is quoted by the judge at MS 508B4.
What does that mean? I mean, it sounds as if it means you can't have an equivalent.
It means that you take each element of the claim and you assess equivalence by reference to each element, but you can't ignore an element. And so to the extent that Lilly's arguments depend on saying, well, just look at the heart of our invention, they simply have no meaning under Spanish law.
How does that work? I mean, how can you have an equivalent then? I think that's what Lord Mance is getting at, and I must say I have some difficulty in understanding how you can have an equivalent then.
You would be
An
asking...
equivalent, by definition, involves a departure from one of the elements.
You'd be asking whether there was an equivalent to pemetrexid disodium, not an equivalent to the whole of the invention. You have to take each element and then identify whether there's an equivalent to that element.
But what does that mean, that because it hasn't got sodium, it isn't equivalent?
Unless it is equivalent to sodium, applying whichever test the Spanish court
But I mean, do you look at the equivalence acontextually or contextually in the context of the invention as a whole? I mean, I struggle to see how that works, but
Well, I'm being taken a bit out of my course because that wasn't a key element of the judge's reasoning, and all I need to do is support the judge's reasoning. Well, then I'll turn on to Spanish question 2, and then if you move again in the judgment, MS 509 1822, you see Spanish question 2, and you will see that is improver 2 as classically applied in England, and it is the date of publication. That's quite clear, that's not contested. Again, that, I think, casts light on some of the ideas suggested that the rest of Europe applies the date of infringement. It
Sorry,
doesn't.
what were we looking at?
1822, 509, paragraph 2
Yeah,
at
I'm
the bottom.
sorry, yes,
Well, I'm sorry if I'm taking this too quickly.
I'm with you, yeah.
So, obviously enough, you can't be told how the variant works or that it works. You can be posited the notion of variation, but you can't be told the future. And well, just to ensure that this is not misunderstood, I think we do need to look at the case of Lundbeck and Sinfer, which is the case the judge cites when he goes on at paragraph 183.
Is that appendix part 3 again?
Yes, indeed.
Which tab?
It is in tab 36,
Thank you.
MS 1805.
Tab what, 36?
Yes. And the relevant passage is at 1844, MS 1844. And we start in the middle of the page at about where it says 29 second question. You see the second question, that is, if the alternative proposed by the respondent's process was obvious to the expert in the material who read the patent on the date of the publication, is a central issue. And then you see the disagreement includes the meaning of obvious. The judgment states that for an alternative to be obvious, it would require that its result was easily predicted by an expert in the material based on their general knowledge and the content of the patent. Add to the fact that the thing is obvious when there's no difficulty in it, when it's clear and evident, and that for the expert it would be obvious if they were left in no doubts about its role in the patented process. And then you see the Lundbeck appeal denies that obviousness is the absence of any doubt. It states the relevant test would be a reasonable expectation of success. On that basis, the appeal states to have reasonable expectation is a much less stringent test. But we cannot agree with a test that is so much less rigorous. Obviousness is easy to see or understand. In order with its etymology obvious, that stands out, that is encountered on the way. So it's much like, well, it is the same as Miss Justice Laddie in Merck and Generics. On this point, we were surprised to hear Mr. Mitchison say that it is common ground that you're told the variant. That may be concealing two things.
Common ground that
You are told the variant. It is common ground that for the purposes of question 2, the skilled person can be told the notion of the variant in order to assess it. But it's obviously inconsistent with Lundbeck and Sinfer that he's told how it works, if that is what Lilly is trying to insert. So, my Lord, Spanish question 2 is improver 2 as classically applied, and then on the facts here, there's just no way round that. So far as we have seen in Lilly's written case, you'll have seen they deleted almost all of the paragraphs of their case on Spain.
Yes.
But the remaining one is the second two sentences of paragraph 301. If we just turn that up very quickly.
Yeah.
And you find that at MS 279 ED 282. Everything has been deleted up until the last three sentences of 301. It's the second and third sentence that are relevant here.
Which page? Sorry, Mr. Raphael.
MS 279,
Thank you. Got it. Yep.
paragraph 301.
Yes, yes. Thank you.
And they make 2 points in the second and third sentences. But both of them essentially just confuse the Spanish test. They assume you know that it will work when you don't know that. And then there's this confused sentence, activists rely upon the safety of such a prediction to achieve regulatory approval of their products. But of course, much later, when they've made them work, they tell the regulator they work. That's nothing.
Yeah, this is different. You say you can't assume they're going to work.
Well, that's right.
And I understand. That's a false point. Yes, I see.
It's a false point.
See your argument. Yeah.
Well, and then that leads us into prosecution history. Given the time, I'll just take this mostly from the judge's judgment.
Right.
And if we could go then to...
That's back to core volume 2.
We're back at core volume 2.
Paragraph.
And the relevant paragraphs are 185 and 184.
Yep.
And if I could just ask you to read 184, 185, and then the application of that in 187.
184, 185, 187.
Well, yes.
We looked at 187 before.
Yes, here it's only 187 starting from the words insofar as
Right.
in the fifth line. In other words, you've seen the point about a restriction to prior art was put to him, he rejected it. That's also his rejection of excluded and added matter cases, because that's the same point. You'll see from his summary of Ros Rocker that it's an entirely general and unqualified proposition. If you have renounced the scope of protection by an amendment in prosecution, that is sufficient. So any attempt to say there is such a qualification is just simply contrary to his findings. Well, just for your note, I'm afraid there was a bundling error, and the document at App 3, tab 44, misses some pages. This matters slightly because our case refers to them. I'm not going to take you to it now, but if I could just
If you give them when we rise, give them to the usher and he'll give them.
Well, then that just leads into the application point. Lilly argue that the amendments aren't clear enough, that there's not enough clear, explicit statements here.
Yeah.
We submit very simply, if you've seen the statements made by Lilly on the file, they say they restrict it to the scope of a particular embodiment. That's quite clear enough. And if you consider to wish to explore the point further, you will see in all the materials, the expert reports, and the cases we've cited, that exactly this kind of circumstance is where the Spanish courts impose the relevant limitations. And the particularly good examples of that are Ranbaxy Warner-Lambert, Appendix 3, tab 41, the Ros Rocker case.
Any particular pages of 41?
Yes, the relevant discussion is at MS 1959, EB 1963. And then another good example is the Rocker case itself, which is the one the judge cites, Appendix 343. And the key passages are MS 1991 to MS 1994.
Thank you.
So, in broad terms, this sort of very clear, conscious limitation, I confine my claims to this, is exactly what the Spanish courts give effect to. Well, that was all I had on Spanish law. There's one general submission on the foreign laws. Lilly complains that it should have a right to expand its challenge and have another go at it. Of course, it has conceded all the points of actual foreign law. And the idea that Lilly is entitled to infinite appeals on questions of application of foreign law to the facts really doesn't bear much examination. Well, those were all I had to say on those points.
I mean, in any of these countries, has the doctrine of equivalence ever succeeded?
Lords, yes. If you have, again, I may trespass outside my zone here, but if you have a patent that does not have the clarity of the desired limitation that this one has, then there may be more scope for equivalence. And equally, you may have no prosecution history where there's a clear expression of an intention to limit.
Thank you very much. Mr. Alexander.
Can I ask you a question, just going back to French law?
Yes.
And the distinction, which seems to be clear in principle, between specific means and general means. And it's talking about the mean, whether it's the same means to perform a function. Is that the right way of looking at it?
My lords, yes, it's possible that I took this just a teeny bit too briskly,
Yes,
because if you see the way in which this was actually applied in one of the cases, it probably makes it a little bit clearer what's going on. If one takes it from Mr. Justice Arnold's judgment to begin with, you'll see that he refers to a number of cases, including Mundi Pharma.
Yeah, well, Mundi Pharma is said to be an outlier. You yourself accept that, and this is the Tribunal de Grande Instance, it isn't even the Court of Appeal, let alone the Court of Cassation. And so it may not be the best case from your point of view.
No, it's not an outlier, and the experts didn't suggest that it was an outlier. To the contrary, what they suggested was that it was an illustration of the more general principle, which one can take from Institut Pasteur, if you prefer. The reason for not going to Institut Pasteur is because the facts are somewhat more complicated, because it relates to a DNA hybridization claim rather than
Well, Institut Pasteur is said to support your opponents. It's said to demonstrate that when you're looking at the particular function, you're looking here at the way in which the chemical operates in the inventive process, and just to isolate the chemical by itself and say, well, we know this chemical. By itself, it has certain characteristics which can't be used without the inventive process, which is the subject of this patent. As I understand what's being said against you is that in order to decide whether similar means is being used, you look at the actual function, and the function is operating in conjunction with folic acid and with P12. And unless you ask, you approach a function like that, and that's a general function, you get the wrong answer, which it said the judge has.
My Lord, actually, we would submit that the position is the other way around. If my Lord looks at paragraph 160,
Right.
The judge certainly cites it, and we submit rightly cites it, as an instance of a case where there was a specific means in question, a specific means of DNA-RNA hybridization to detect the HIV with a probe composed of a particular DNA fragment. The function of the specific means was known at the priority date, and so the claim integer could not be extended to cover any other method of hybridization that achieved the same function. And that's relevant for two levels. First of all, it is one of the sources of the distinction between moyen particulier and moyen généreux. But it is also an instance of the application of that principle, taking into account that which was known about the specific integer in question in that context. So in our respectful submission, it is a It's not establishing the contrary principle. The contrary principle was established.
No, perhaps I may be mistaken on that. It's actually another case in the Court of Cassation. It's DEL and Helge, which they say is the better example.
Ah, right. That's the one that the experts don't refer to, and where we respectfully submit that it doesn't establish any principle of any kind, and it is actually limited. It doesn't deal with the issue, we would submit, of the distinction that is to be drawn between the, as it were, integer by integer specific means and the analysis, which we would respectfully submit is the one that the French courts apply. It might be easier if I just very briefly draw your Lordship's attention, if you would like, just to where you at least find the two instances of the moyen particulier being applied in practice. If you take up the French bundle, so Appendix Part 3, France, and go first of all to tab 17, that's MS 1425.
Yeah.
Which is a tramadol controlled release formulation patent. And just so that your Lordships have the location of this in the case, this is referred to as an instance of the principle being applied. So it's not, in a sense, a source of law in that sense, but it is a illustration of the application of it. And if I could just, so that your Lordships have the way in which the evidence was developed before the judge, show you, before we go to Monte Pharma, where it is referred to and the location in the case.
Yes.
It is Professor Galou's report, that's our expert's report, at the same bundle, tab 2, at page 1260.
Yeah.
And he sets out the law in the following way. First of all, he identifies the principle, essentially, and refers to Pasteur, and then he gives this as an example of the application, saying that in the Mundi Pharma case, Claim 1 covered an application of tramadol and cellulose, either as an active, and the alleged infringer used xanthan gum instead of cellulose. And in that case, the doctrine of equivalence was ruled not to apply, and the extract, that is the relevant extract for the purposes of this indication, or this example, is on the next page, so page 1, MS 1261. And perhaps your Lordships might want to just read through that over to 1262, then we don't need to go to the case.
May it be said to depend on how you define it. If you define this as involving what the original drug perotrexin did, it's one thing. But if you say that the new disclosure is that with the benefit of the addition of vitamin B12, it doesn't have the unfortunate side effects, then you come to another result, wouldn't you?
Well, it is possible, but it doesn't really look as though the French courts have analysed it in quite that way, because they look at the individual integer and determine whether the individual integer was old or new. And if I may just briefly, or known in the context of specific means, may I briefly just explore why that is a sensible approach? Because if you have something that is described, you're describing something that is completely new in its, where you may have a range of ways of doing something that is actually completely new, then you might say, well, there's no kind of point of reference for determining what should be regarded as sufficiently similar to it. Yes. So you can have a wider scope. If, on the other hand, you have something which is itself known as a specific thing, so that there is a specific means for a specific thing, then, in principle, it's much easier to say, well, since that is known as something, there is a good reason for saying that the patentee would have confined themselves to that which was known, thinking about it in English terms. And that is why that moyen particulier is to be regarded as limited in that respect. And the shades of that do come out from the Mundipharma case, where precisely because cellulose, or the cellulose ether, was known indeed as a slow-release co-formulation substance, and had been disclosed in an earlier patent, as, of course, pemetrexid disodium has in this case, the court said, well, actually, we're not going to treat a claim which is to a specific cellulose ether as covering something that is different from that, even though it is technically equivalent. And the technical equivalent, the issue there was a xanthine gum. And that's why we respectfully submit that approach actually highlights the correctness of the judge's finding here. If you read the particular extracts of the Mundipharma case, and in particular look at the context of the claims there, you'll see that is supported. But that requires possibly looking at the whole judgment, and I wouldn't invite my lord to do that right now. You'll find that at tab 17, and the patent in question, or the scope of the patent, is set out there at MS 1480 to essentially 1434, where there is a controlled release dosing schedule, which is then given effect by a tramadol and cellulose ether combination. In fact, they're not relevantly, but interestingly, also a Swiss form claim. There are, of course, other examples, but I think for the purposes of answering my Lord's question, that is probably all I need refer my Lord to now. Does that provide a sufficient answer, at least?
I think that's helpful.
The only question is that I'm afraid I am slightly over budget.
Not your fault.
I'd hoped to complete indirect infringement by close of play today.
That's it, is it?
That is it.
And
on
how long
my
do you
case?
be on?
And I anticipate I will be no more than about 20 minutes. But I think it would probably be more sensible if we started that tomorrow, subject to my Lord's.
Well, I noticed that you budgeted for 2.5 days, but you've allowed for the fact we might stray into tomorrow afternoon. I think the sensible course, subject to my Lord's, is that we resume again at 10:30 tomorrow, and if we stray over lunch, we stray over lunch. Does that seem sensible? Right, and don't apologise, it's not your fault, we put a lot of questions to you. Thank you very much then. We'll adjourn now and resume again at 10:30 tomorrow. Thank you all. The court's now adjourned.